I had a blasting permit sitting in a filing cabinet for 11 years. Never used it. Renewed it every 2 years because my lawyer said to, and because I am the kind of man who does not let rights expire. When a festival promoter built a concert stage 50 feet from my fence line and started selling tickets to 10,000 strangers, he did not know about that cabinet. He did not know about the permit. He had looked at my land, seen a quiet man with an old gravel pit, and decided I was not a problem. That was the only mistake he needed to make. My property is 42 acres in a county most people have never heard of. There is a gas station at the highway turnoff, a grain elevator, a feed store that has been run by the same family since 1987. If you blink on the county road, you will miss the turn to my gate entirely, which is how I prefer it. I bought the land in 2013, paid cash for most of it. The previous owner was a man named Harlan Beach, 70s, bad knees, had been pulling limestone out of the lower basin since before I was born. When he sold, the excavators left. The permit stayed. It transferred with the deed, same as the mineral rights, same as the access easements. My attorney walked me through all of it at the closing table. He set the permit folder in front of me and said, "Keep renewing this, even if you never touch it." I asked him why. He said, "Because rights you don't use can still be rights somebody else wants you to give up." I kept renewing it. Every 2 years. Fees paid. Safety documentation filed. State Mining Board notified. The permit sat in a grey folder in the second drawer of a filing cabinet in my office, under a bag of loose wire staples and an old aerial photograph of the property from 1994. I ran cattle on the upper 40 acres. The quarry basin sat untouched. Grass growing back in the cracks. Rainwater pooling at the low end in spring. Quiet. I'm not a complicated man. I get up early. I do the work. I go to bed. That was my life on that land for 9 years, and I was satisfied with it. My neighbour to the east was Mrs. Aldine Pruitt, 71 years old, had lived on her 12 acres since Carter was president. She grew tomatoes and kept a small flock of chickens and waved every time I passed her mailbox. We had an arrangement where I kept her fence line trimmed on my side, and she left a paper bag of tomatoes on my gate post in August. Nobody negotiated it. It just happened. To my west was the Callaway tract, 90-some acres, flat in the lower section, wooded on the north end. It had sold 3 times in about 10 years. Corn operation that didn't take. An agritourism thing, pumpkins, hay rides, that lasted 2 seasons. Then it sat vacant for a while, which suited me fine. Vacant land is quiet land. In the spring of 2022, I was at Dale's feed store, loading a bag of mineral mix into the back of my truck, when Dale leaned on the counter and said, almost like he was talking about the weather, that the Callaway tract had sold again. "Know anything about the buyer?" I asked. Dale shrugged. "Out of state." That's all anybody said. I drove home. I didn't think much of it. 2 weeks later, there was a survey crew on the lower field of the Callaway tract, orange flags in the grass along my fence line. I stood at my gate and watched for a few minutes. Surveying is normal. People buy land and they survey it. I went back to work. I should have walked over and introduced myself that same day. I didn't. The survey crew was gone by Friday. The following week, grading equipment showed up. A bulldozer and a skid steer working the lower flat section of the Callaway tract. I could hear it from my barn, that low hydraulic groan that carries across open land in the morning when everything else is still. I didn't go look. A man grading his own field is his own business. But it went on for 2 weeks straight. Then 3. That's longer than you grade for crops. I mentioned it to Dale at the feed store. He had heard something by then. He always had. Said the new owner was some kind of event promoter. Did outdoor music festivals. Had done a couple down in Georgia or Tennessee, he wasn't sure which. I stood there for a second with that information. "How big?" I asked. Dale didn't know. I drove home and looked the man up that evening. It didn't take long. His name was Devin Marsh. He had a website for his company, Marsh Event Group it was called, and the website had photographs, aerial shots of festival grounds, crowds, stages with rigging and lights, sponsor banners. Porta potties lined up in long rows along what used to be somebody's fence line. One of the events listed had drawn 9,000 people over a weekend. I looked at that number for a while. Then I looked at a map of my property and his, side by side, on the county assessor's website. His lower field, the flat section he'd been grading, sat directly adjacent to my western fence. My quarry basin was maybe 200 feet from that fence on my side. The access road that ran to the quarry head came within about 60 feet of the boundary. I am not a man who panics, but I'm also not a man who ignores what he's looking at. I called my attorney the next morning. His name is Garrett. He has handled my land matters since I bought the property. I told him what I'd found. He listened without interrupting, which is one of the things I appreciate about him. When I finished, he said, "Has he contacted you at all?" "No," I said. "Has anyone from the county contacted you?" "No." There was a pause. "Okay," he said. "Let me look at the zoning on that parcel and see what he'd need to operate a commercial event venue out there. I'll call you back." He called back that afternoon. What he told me was this: the Callaway tract was zoned agricultural, same as mine. Commercial event venues in that zoning classification required a conditional use permit from the county. They also required notification of adjacent landowners within 500 feet before the permit hearing. I was well within 500 feet. I had received no notification. "So he hasn't applied yet," I said. "Not that I can find," Garrett said. "Which means either he's still in the planning phase or he's planning to operate without the permit." I thanked him and hung up. I walked out to my western fence line that evening, just before dark. The grading was done. The lower field was flat and smooth and pale, like something scraped clean. There were stakes in the ground with coloured ribbon tied to them, the kind contractors use to mark where structures are going. One set of stakes was maybe 40 feet from my fence. I stood there in the cooling air and looked at those stakes for a long time. Then I went inside and took the grey permit folder out of the filing cabinet and set it on my kitchen table. I didn't open it that night. I just left it there. The permit notice came in the mail on a Thursday. Not to me. I found out about it second-hand, which tells you everything about how Devon Marsh operated. Mrs. Pruitt called me that evening. She almost never called, so when her number came up on my phone, I answered it on the first ring. She said she had received a letter from the county planning office. A notice of conditional use permit application for the Callaway tract, commercial outdoor event venue. She read me the relevant parts in her careful schoolteacher voice. I asked her when the hearing was scheduled. 22 days out, she said. I had received nothing. I drove to my mailbox and checked it, even though I had already checked it that morning. Grocery circular. A bill. Nothing from the county. I called Garrett the next morning and told him. He said he'd look into it. He called back within the hour and said the application had been filed 4 days ago. The county had sent notification letters to adjacent landowners as required. Mrs. Pruitt's letter had arrived. Mine had not. Could be a mail delay, Garrett said, in a tone that suggested he didn't fully believe that. Or it could be the address they used was wrong, I said. Garrett checked. The address on the notification form was my property address, the rural route number, not my mailing address, which is a P.O. box in town. 2 different addresses. The county had used the property address. Mail sent to that rural route number sometimes arrived. Sometimes it didn't. Depended on the carrier, depended on the day. Is that my problem or theirs? I asked. Technically, the county fulfilled their obligation by sending it, Garrett said. But you have standing to appear at the hearing regardless of whether you received the notice. Adjacent landowner status gives you that. Then I'll be there, I said. I went to the hearing. The County Planning Commission met in a low brick building attached to the courthouse. Fluorescent lights, folding chairs, a table at the front where 5 commissioners sat with water bottles and manila folders. About 30 people in the room. A few I recognized, most I didn't. Devon Marsh was there with 2 other people. A woman with a laptop and a younger man in a vest who kept looking at his phone. Marsh himself was maybe 6 feet, lean, wearing a jacket that was slightly too new for a county planning meeting. He had the kind of easy confidence that comes from doing this before and winning. He presented first. The woman with the laptop ran a slideshow. Aerial renderings of the proposed venue layout, parking areas, a main stage, a secondary stage, vendor corridors, estimated attendance for the inaugural event, 8,000 people over 2 days. The commissioners asked questions. Marsh answered them smoothly. Traffic management plan, yes, he had one. Sanitation, contracted out, he said, handled by a professional company. Noise ordinance compliance, yes, they'd be within county limits, he said, they always were. One of the commissioners asked about neighbouring properties. Marsh said, and I am not paraphrasing, that the surrounding area was primarily agricultural and that the nearest residential structure was approximately half a mile from the proposed stage location. I was sitting in the 3rd row. Mrs. Pruitt was sitting next to me. Her house is 600 feet from his property line. I wrote that number on the notepad I had brought. I underlined it. When the commissioner opened the floor for public comment, I stood up. I am not a man who enjoys speaking in public. I stood up and I stated my name and I gave my property address for the record. I said I was an adjacent landowner to the west of the Callaway tract. I said I had not received the required notification letter despite being well within the 500-foot radius. I said I was appearing anyway because I had learned of the hearing through another neighbour. Then I said that the statement about the nearest residential structure being half a mile away was incorrect. I said Mrs. Aldine Pruitt, seated next to me, had owned her home at its current location since 1978, and that her front porch was approximately 600 feet from the applicant's property line, not half a mile. I sat down. The room was quiet for a second. One of the commissioners, older man, reading glasses on a cord around his neck, looked over at Marsh's table. "Mr. Marsh, can you clarify the residential proximity figures in your application?" Marsh leaned toward the microphone. He said there may have been a measurement discrepancy in the preliminary site assessment. He said they would, of course, verify all distances before proceeding. Discrepancy. That was the word he used. Mrs. Pruitt, beside me, wrote something in the small notebook she had brought. She was the kind of woman who wrote things down. I respected that. The commissioner made a note. The hearing continued. By the end of it, the commission had not approved the permit. They had tabled it pending additional documentation, revised site survey, corrected residential proximity measurements, and a formal noise impact assessment. Marsh would need to resubmit and schedule a second hearing. He didn't look at me when he left. His assistant with the laptop did, briefly. The young man in the vest did not look up from his phone. I drove home. That should have been the end of the friction. He would resubmit, the commission would eventually approve a modified version of the permit, he would run his festivals, I would run my cattle, and we would tolerate each other across a fence line the way rural neighbours sometimes do. It happens. Land use conflicts get resolved through process. But Marsh did not wait for the second hearing. 6 weeks later, on the first Saturday of October, I was in my barn at 7 in the morning when I heard it. Bass. The kind that doesn't travel as sound so much as pressure. You feel it in your sternum before you hear it with your ears. I stood still for a moment, thinking I had imagined it. I hadn't. I walked out to the western fence. On the Callaway tract, in the flat graded field, there were vehicles. A lot of them. A stage structure was up. Not a permanent one, a rigged portable stage with a roof truss system. There were generator trailers humming along the far tree line. And there were people. Not 8,000, not yet, but there were cars filling a makeshift lot in the upper field and a steady stream of more coming down the county road. He was running the event without the permit. I stood at that fence line for probably 2 minutes, just looking. Then I went inside and called Garrett. He answered on the third ring. I told him what I was seeing. He was quiet for a moment and then he said, "Take photographs." Time-stamped. "As many as you can. I'll start drafting a complaint to the county zoning office. This is an unpermitted commercial event on agriculturally zoned land, and it needs to be documented from this moment forward." I got my phone. I took photographs. I took them every 30 minutes for the next 4 hours. By noon, there were approximately 3,000 people on that field. By 2 in the afternoon, one of them had cut my fence. I found it on the south end of my western fence line. 3 posts down from the corner marker, someone had cut the wire. Not accidentally snagged it, not pushed through and bent it. Cut it. Clean diagonal cuts on 2 strands of barbed wire, the kind you make with wire cutters or fence pliers. The ends were bright where the metal was fresh. This had happened that day. 2 of my cattle had walked through. They didn't go far. They were in the scrub grass along the inside of the Callaway tree line, maybe 80 yards from the gap, grazing like nothing had happened. I got them back without much trouble. Patched the fence temporarily with what I had in the truck, enough to hold until I could do a proper repair. But I stood at that cut fence for a long time before I did anything else. Cutting a fence is not an accident. It is not something that happens when someone leans against wire or catches a boot. Someone had looked at my fence, taken out a tool and deliberately cut it. Whether they wanted a shortcut through my property or access to the Quarry road or just thought it didn't matter, I don't know. What I know is that it was intentional, and it was on the day of Marsh's unpermitted event, and 3,000 of his ticketed guests were the only people within 2 miles who weren't supposed to be there. I photographed the cut ends. I photographed the postmarkers on either side. I photographed the footprints in the soft ground near the gap, boot treads, at least 2 different sizes. I photographed my cattle before I moved them, showing their location relative to the gap. Then I called the county sheriff's non-emergency line and reported a fence cutting and livestock at large. A deputy came out about 90 minutes later. Young guy, couldn't have been more than 26. He looked at the fence, looked at my photographs on my phone screen, wrote things in his notebook. He asked if I knew who had done it. I told him I didn't know specifically, but I told him about the event next door, about the lack of a conditional use permit, about the timing. He wrote that down too. He gave me a report number before he left. I wrote it in my own notebook and photographed the page. That evening I sent Garrett everything. Photographs, deputy's name, report number, timestamps. He replied within the hour. He said he was filing a formal zoning complaint with the county on Monday morning and that he was also sending a written notice to Marsh directly, documenting the fence damage and the livestock incident and establishing that I held him responsible for creating the conditions that led to it. I asked Garrett whether Marsh could be held liable for the fence cutting itself, even if we couldn't identify who specifically had done it. Garrett said that was a more complicated question, but that creating an attractive nuisance, drawing thousands of people to an unpermitted event adjacent to private fenced land, created a plausible basis for negligence. Not a certainty, he said, but a basis. I slept on that. The next morning I did the permanent fence repair myself. New wire, new staples, reset one post that had shifted. Took me most of the morning. The base from the Callaway tract had stopped sometime during the night. The field over there was quiet now, just tire ruts in the graded dirt and a scatter of trash along the fence line. Plastic cups, a tarp someone had left, a camping chair with a broken leg, all of it on my fence line. Not his. I photographed that too. The county zoning office received Garrett's complaint on Monday morning. By Wednesday, nothing had happened. By the following Monday, still nothing. I am a patient man, but patience is not the same as passivity. I called the zoning office myself on that Monday, spoke to a woman who said the complaint had been received and logged and was under review. I asked what under review meant in terms of timeline. She said she couldn't give me a specific timeline. I asked who was handling it. She gave me a name, a zoning enforcement officer named Carl Deeds. I asked to speak with Carl Deeds. Carl Deeds was not available. I left my number. He did not call back that day, or the next. On Wednesday, I drove to the county building in person. I am not sure why, but something about sitting on a phone waiting for callbacks felt wrong to me, like I was allowing the pace of this to be set by someone else. I walked into the zoning office and asked for Carl Deeds at the front counter. The same woman I had spoken to on the phone looked at me for a moment and then went to find him. Deeds was a heavy-set man in his 50s with a county lanyard and the careful eyes of someone who had learned to say very little in official settings. He shook my hand. We sat in 2 chairs near his desk, not at it, which I noticed. Like he wanted it to feel informal. He said the complaint was being reviewed. He said the event in question had already concluded and that enforcement actions for zoning violations were typically handled on a going-forward basis. He said that since no permit had been issued, there was technically no permit violation. Rather, the issue was the absence of a required permit, which was a different classification of infraction. I looked at him. So running an unpermitted commercial event on agricultural land isn't a violation, I said. It's just an absence of compliance. He shifted slightly. It's a zoning infraction, yes. But the event is over. What we'd be looking at now is ensuring future events don't proceed without proper permitting. And the fence cutting, I said. And the livestock. That's a sheriff's matter, he said. Outside our jurisdiction. I thanked him for his time and left. I sat in my truck in the parking lot for a few minutes. Not angry exactly. More like recalibrating. When you go into a room expecting one thing and come out with another, you need a moment to adjust your understanding of how things actually work. What I understood now was this. The county was not going to move aggressively against Marsh. Maybe because he had money. Maybe because a future tax-generating event venue looked attractive to someone in that building. Maybe just because Carl Deeds did not like paperwork. I didn't know the reason, and the reason didn't particularly matter. What mattered was that I could not rely on the county to be my instrument here. I called Garrett from the parking lot and told him what Deeds had said. Garrett was quiet for a moment, and then he said, "Okay. Then we build the record ourselves, and we go around them if we have to." "What does that mean practically?" I said. "It means every violation, every incident, every piece of damage gets documented and dated. It means we file with the State Agricultural Board regarding the livestock incident. It means we look at whether the county's non-response to a valid zoning complaint is itself actionable. And it means," he said, "that when Marsh applies for that permit again, we are going to be the most prepared adjacent landowners that Planning Commission has ever seen." I drove home. 2 weeks later, Marsh resubmitted his conditional use permit application. The second hearing was scheduled for 6 weeks out. And 3 weeks before that hearing, on a quiet Tuesday evening, I came home to find a man I had never seen before walking the perimeter of my quarry basin with a measuring tape. I stopped my truck at the quarry access gate and got out. The man was maybe 40, work boots, a canvas jacket. He had a clipboard in one hand and the end of a measuring tape in the other. There was a truck parked on my access road that I did not recognize. No company logo on the door, just a plain dark blue pickup. I walked toward him. He saw me coming and straightened up. "This is private property," I said. He nodded like that was a reasonable observation. "Yes, sir. I'm just doing a quick assessment." "Shouldn't take long." "An assessment of what?" I said. He looked at his clipboard. "Topography and site suitability for a potential overflow parking and staging area." I stood there for a second. "Who sent you?" I said. He gave me the name of a site planning firm I didn't recognize. I asked who had hired the firm. He said he wasn't sure of the end client's name, that he just got the assignment from his supervisor. I told him to take his measuring tape and his clipboard and get off my property. I told him he was trespassing and that I was going to photograph his truck and his plates before he left, which I did, standing at my gate while he drove out. I called Garrett that evening. Garrett said it was almost certainly Marsh. A site planner assessing an old quarry basin for overflow parking and staging meant Marsh had looked at my land and decided it was useful to him. Whether he planned to approach me about leasing it, or whether someone had simply told him the land was dormant and he assumed it was available, Garrett couldn't say. What Garrett said next was the part that stayed with me. He said he's been making inquiries. "I've heard from 2 people now that Marsh has been telling people locally that the quarry property is likely to come available, that the owner is a holdout, but that these things work themselves out." I asked Garrett what that meant exactly. A holdout? Garrett said it meant Marsh had been characterizing me, to contractors, to vendors, possibly to county officials, as a temporary obstacle, not a permanent one, someone who would eventually be managed. I sat with that word for a moment. Managed. I've been farming and ranching on that land for 11 years. I have paid every tax, renewed every permit, maintained every fence line. I have never caused a problem for anyone. And this man, who had been my neighbor for less than a year, who had run an unpermitted event next to my property, whose guests had cut my fence and scattered my cattle, this man was telling people I was a holdout who would be managed. I went to the filing cabinet that night. I took out the grey permit folder and this time I opened it. The blasting permit was current, renewed 8 months ago, valid for another 16 months. It authorized explosive excavation within the permitted zone, which encompassed the entire quarry basin and the surrounding buffer area. The permitted zone boundary, per the original survey attached to the permit, ran to within 90 feet of my western property line, 90 feet from Marsh's fence. The permit had notification requirements. Before any blast, I was required to notify adjacent landowners and the county sheriff's office a minimum of 72 hours in advance. I was required to conduct a pre-blast survey of nearby structures. I was required to stay within approved charge weights and follow state safety guidelines. All of that was manageable. I read the whole document that night, every page. I had skimmed it at closing and filed it and mostly forgotten it for 9 years. Now I read it like it was something I might actually use, because I was beginning to think I might actually use it. Not that night. Not yet. There was a hearing coming and I still believed in process. But I wanted to know exactly what I held in my hands before I walked into that room again. I put the folder back, but I moved it to the top drawer. The 6 weeks before the second hearing were the most organized I have ever been in my life. I am not naturally a paperwork person. I run cattle. I fix fences. I prefer physical problems with physical solutions. But Garrett had said we were going to be the most prepared adjacent landowners that Planning Commission had ever seen, and I took that seriously. I started treating the documentation the way I treated any other farm task, scheduled, methodical, done right the first time. I bought a dedicated notebook, narrow-ruled, black cover, nothing special. I dated every entry. Every observation went in, time, weather, what I saw, what I heard. Bass carrying across the fence line from Marsh's property during what turned out to be a private sound check he ran on a Saturday afternoon without any notice. 2 vehicles I didn't recognize parked on my access road easement for about 40 minutes on a weekday. A pile of construction debris, lumber scraps, metal strapping, plastic sheeting that appeared along my fence line after Marsh's crew erected a secondary equipment shelter on his side. Each entry in the notebook got a corresponding photograph on my phone. I backed the photographs up to a separate drive every Sunday evening. I also started pulling records. Garrett had access to things I didn't, but some of it I could do myself. The county assessor's website had the full permit application on file, including Marsh's submitted site plan. I printed it. I compared the measurements on his site plan to what I could observe from my fence line and from publicly available satellite imagery. There were discrepancies. Not enormous ones, but consistent ones. Distances that appeared slightly larger on paper than they were on the ground. I printed the satellite images and marked them up with a red pen. Mrs. Pruitt had been keeping her own records. She had written down every date she'd heard construction noise. Every morning she'd had unfamiliar vehicles turning around in front of her mailbox. Every piece of trash she'd found along her fence line. She had a composition notebook that was already half full. When I went to visit her one afternoon, she set it on the kitchen table between us and we compared notes. Her documentation was better than mine. Neater handwriting. More precise times. She had been doing this, she said, since the survey crew first showed up, before I'd even thought to start. I told her that. She shrugged and said she had lived next to that track for 40 years and had learned to pay attention when something changed. I asked her if she planned to appear at the second hearing. She said she planned to bring her notebook, her land deed, a copy of the county noise ordinance she had printed from the county website, and her late husband's survey map of her property showing exact distances to the Callaway tract boundary. I did not feel sorry for Devin Marsh in that moment, but I felt something adjacent to it. The other thing I did during those 6 weeks was hire my own noise consultant. Garrett suggested it. There was a firm 2 counties over that did acoustic assessments for exactly this kind of land use dispute. They came out on a weekday, set up monitoring equipment along my fence line and near my barn, and at 2 points on Mrs. Pruitt's property with her permission. They ran the assessment over a weekend that happened to coincide with another of Marsh's sound checks, his second one, also unannounced. The readings came back the following week. At my barn, during the peak of Marsh's sound check, the decibel level had reached 78. The county noise ordinance for agricultural zones set a limit of 65 decibels for neighbouring properties during daytime hours. At Mrs. Pruitt's front porch, the reading had hit 81. 81 decibels on an old woman's front porch, a porch she had been sitting on since 1978. I read that number in the consultant's report, and I thought about her composition notebook and her husband's survey map and the bag of tomatoes she left on my gatepost every August. I called Garrett and read him the number. He was quiet for a moment. Then he said, "Good. That's very good." The second hearing was on a Thursday evening in November. Cold night. Parking lot outside the county building had more cars than I'd ever seen there. I recognized a few. Mrs. Pruitt's sedan, a truck belonging to a farmer named Roy Steck, who had land about a mile north of the Callaway tract. Some I didn't recognize. Whether they were Marsh's people or concerned neighbors, I couldn't tell from the parking lot. Inside, the folding chairs were nearly all taken. I found 2 seats near the aisle, third row again, and held one for Mrs. Pruitt. She came in a few minutes later wearing a wool coat and carrying a canvas tote bag that I knew held the composition notebook, the deed, the noise ordinance printout, and her husband's survey map. She sat down, set the bag on her lap, and looked straight ahead. Marsh was at the front table again. Same woman with the laptop. Different younger man this time, no vest, a proper suit jacket, and a third person I hadn't seen before, a man in his 60s with the careful stillness of someone who had been in a lot of these rooms. Garrett told me later he was a land use attorney Marsh had hired between hearings. So Marsh had lawyered up. That was fine. Garrett was in the seat directly behind me. The commission ran through the resubmission. Marsh's attorney presented first this time. The site planner had been replaced by a professional land use consultant, the residential proximity measurements had been corrected, the noise management plan had been expanded. They had answers for everything the commission had flagged at the first hearing. It was a polished presentation, the kind that cost money. When public comment opened, I let Mrs. Pruitt go first. She stood up slowly, the way a person does when their joints have earned the right to take their time, and she placed her husband's survey map on the table at the front. She identified herself for the record. She stated how long she had lived on her property. Then she walked the commission through the map, measured distances, boundary markers, the location of her home relative to Marsh's proposed stage site. She said the corrected figure in Marsh's resubmission placed her home at 840 feet from the stage. Her husband's survey, conducted in 1991 by a licensed county surveyor, placed her property boundary at 512 feet from the Callaway tract line. Her home sat a further 120 feet inside that boundary. 632 feet total, not 840. She set the survey map on the commission table and sat back down. One of the commissioners, a woman this time, younger, reading glasses pushed up on her forehead, picked up the survey map and looked at it. Then I stood up. I stated my name and my property address for the record. I submitted the noise consultant's report as a formal exhibit. Garrett had arranged this in advance, so the commission clerk already had copies. I walked through the findings. The county ordinance limit of 65 decibels for agricultural zones. The reading of 78 at my barn. The reading of 81 at Mrs. Pruitt's front porch. I said those readings were taken during an unannounced sound check, not during an actual event with full production levels. I said a reasonable inference was that a full event would produce higher readings than a sound check. Marsh's attorney objected, not formally, since it wasn't that kind of proceeding, but he spoke up and said the sound check had been conducted within legal operating hours and that the noise consultant's methodology hadn't been independently verified. I had anticipated that. I said the consultant was a licensed acoustic engineer with 14 years of experience in land use assessment, that his methodology was documented in the report the commission now held, and that if the applicant wished to commission his own independent assessment, I had no objection, provided the hearing was postponed until both assessments were available for comparison. Postponement was the last thing Marsh wanted. The commission chair looked at Marsh's attorney. The attorney conferred briefly with Marsh. Then he said they did not require a postponement and that they were confident the noise management plan in the application addressed the concerns raised. I sat down. Garrett leaned forward from the row behind me and said very quietly, "Good." The commission tabled the application again. They requested an independent noise assessment, a revised site plan reconciling the distance discrepancies between Marsh's submission and Mrs. Pruitt's survey, and a formal response to the zoning complaint that was still open from the first unpermitted event. Marsh's attorney said they would comply. Outside in the parking lot afterward, Mrs. Pruitt buttoned her wool coat against the cold and said, without looking at me, "He's going to try to wait us out." I said I thought she was probably right. She said, "I've been here 40 years. He's been here 8 months. She got in her car and drove home. 3 weeks after the second hearing, Marsh ran another event. Not as large as the first one. Maybe 1,500 people. A Friday night into Saturday morning, which was worse in some ways than a daytime event, because the sound carried differently at night. Across flat agricultural land in the dark and cold of November, bass travels further than you would think. I lay in my bed at 2 in the morning, listening to it move through the walls of my house. I got up, dressed, went out to the porch. I could see the light glow from the stage rigging over the tree line on the Callaway tract. Orange and blue, pulsing with the music. My cattle were bunched at the far end of the upper pasture, as far from the western fence as the field allowed. Cattle don't like sustained bass at close range. It stresses them. A stressed animal loses weight, loses condition. That has a dollar value. I documented it. Photographs of the light glow, time-stamped. A video taken from my porch that captured the audio clearly enough that you could hear the bass and, in quieter moments between songs, a faint crowd sound. I noted the time in my notebook. I noted that my cattle were displaced from their normal grazing pattern. Then I called the sheriff's office. Not the non-emergency line this time. I called the main line and asked for the duty deputy. I explained the situation: unpermitted commercial event, active zoning complaint, noise ordinance exceedance already documented by a licensed consultant. I gave them the case number from the fence cutting report back in October. I asked them to send someone. They sent someone. Eventually. A different deputy this time, older, a man named Greer. He arrived at my gate at about 3:15 in the morning. I walked him to the western fence. We stood there together listening. The music was still going. Deputy Greer looked over the fence line for a moment. Then he said, "Has he got a permit for this?" I said he did not. I said the conditional use permit application was currently tabled pending additional documentation after 2 hearings. I said I had a copy of the open zoning complaint if he needed the reference number. Greer wrote things in his notebook. He said he'd go over and have a word. I watched from my fence line as his cruiser headlights moved along the county road and turned into the Callaway tract entrance. The light stayed on for about 20 minutes. Then the music stopped. Not gradually, just stopped. I stood at the fence in the quiet for a moment. The light glow faded. I could hear my cattle shifting in the dark pasture. I went back inside and wrote the time in my notebook. 3:47 a.m. The following Monday I was at the county building again. This time I asked to speak with the county administrator, not the zoning office. Her name was Patricia Sowell. She had a proper office, not a desk near a counter. She had been the county administrator for 9 years, and she had the measured, slightly tired demeanour of someone who had handled a great many problems that other people had failed to handle first. I sat across from her desk and I laid it out. Not emotionally, just sequentially. First event, no permit, open complaint, no enforcement action. Second hearing tabled. Second event, no permit, deputy called at 3 in the morning. Music stopped only after law enforcement appeared on site. I put copies of everything on her desk as I talked. The zoning complaint filing. The noise consultant report. The deputy's report from the fence cutting. The deputy's name and badge number from the previous Friday night, which I had written down at my gate before Greer drove over. Mrs. Sowell looked at the documents. She picked up the noise consultant report and read the first page. Then she looked at me and said, "Mister, how many times have you been to this office in the past 2 months?" I said 4 times, including today. She said, "And how many responses have you received?" I said 1, from Carl Deeds, which had been unsatisfactory. She set the report down and folded her hands on her desk. She said she would personally review the open zoning complaint and that she would have a formal response to me in writing within 10 business days. I thanked her and stood up to leave. At the door she said, "Leave me those copies." I had brought 2 sets of everything. I left her one and kept the other. 10 days later I received a letter on county letterhead. Patricia Sowell's signature at the bottom. It said the county had issued a formal notice of zoning violation to the owner of the Callaway tract. It said that any further commercial events conducted without a valid conditional use permit would result in a civil penalty of $1,500 per day of operation, and that the county reserved the right to seek an injunction prohibiting events pending permit resolution. $1,500 a day. For a man running events that grossed tens of thousands of dollars a weekend, $1,500 was noise. But the injunction threat was not nothing. An injunction meant a court. A court meant a judge. A judge meant something Marsh couldn't manage with a polished presentation and a hired attorney. I folded the letter and put it in the grey folder with the blasting permit. They were starting to keep each other company in there. The violation letter didn't stop him. I want to be clear about that because I think people assume that official correspondence changes behaviour. Sometimes it does. With Marsh it did not. What it did was make him more careful. The next event he ran, a Saturday in early December, maybe 1,000 people, he had someone posted at the entrance checking names against a list. No public ticketing. Private event, he would later claim. Friends and family. Friends and family who had each paid $120 to attend, according to a ticket stub that found its way to Garrett through a contact I'd rather not specify. Private event exemptions in the county code applied to genuine private gatherings, not to ticketed admissions on commercially graded land with a professional stage rig and contracted sound engineers. Garrett documented it, added it to the file. The file was getting thick. What I hadn't anticipated was what Marsh did next. Not another event. Something quieter and in some ways more aggressive. He applied for a variance, not a conditional use permit, a variance. Specifically, he applied to the County Board of Zoning Appeals for a variance that would reclassify a portion of the Callaway tract, the lower graded field and the adjacent buffer zone, as light commercial rather than agricultural. If granted, it would eliminate the need for a conditional use permit entirely. He could operate a commercial venue by right. Garrett called me the morning the application was filed. "He's going around the Planning Commission," Garrett said. "Can he do that?" I said. "He can apply. Whether the board grants it is another question. Variances require demonstrated hardship. The applicant has to show that strict application of the zoning code creates an unnecessary burden. It's a higher bar than a conditional use permit in some ways. But if he gets it," I said, "if he gets it, the Planning Commission hearings we've been to become largely irrelevant. He operates commercially by right and our leverage drops significantly." I sat with that. "When's the hearing?" I said. 6 weeks. 6 weeks. Same interval as before. Marsh operated on a 6-week cycle, it seemed. Apply, wait, push forward. Apply, wait, push forward. He was patient in his own way. He had resources, and he had a lawyer, and he had the particular confidence of a man who believed that rural counties eventually bend toward development and money. He wasn't entirely wrong about that. Rural counties do sometimes bend that way. But I had spent those weeks building something he hadn't accounted for. I had contacted Roy Steck, the farmer to the north. He had his own documentation, vehicles on his access road, a drainage issue he believed was connected to Marsh's grading work. 2 incidents of his dogs being disturbed by overnight sound. He was willing to appear at the variance hearing. I had contacted 2 other landowners in the 500-foot notification radius who had also received the original hearing notice. Neither had appeared at the first 2 hearings. Both agreed to appear at the variance hearing when I explained what a variance would mean for the entire surrounding area, not just my property and Mrs. Pruitt's. I had asked Garrett to research Marsh's previous festival operations in Georgia and Tennessee. It took 2 weeks, but Garrett found what he was looking for. One of the previous venues, a property in a rural county in Tennessee, had a judgment against Marsh Event Group for unpermitted land use, noise ordinance violations, and failure to restore the property to its pre-event condition. The judgment had been settled out of court. The amount was sealed, but the case record was public. I printed it, added it to the file, and I called the state mining board. Not about anything urgent. I just called and asked a procedural question. I asked whether my existing blasting permit required any additional authorization before first use, given that the permit had been held continuously but never activated. The woman I spoke to checked my file. She said no additional authorization was required. The permit was valid. Notification procedures applied as always, 72 hours to adjacent landowners and the sheriff's office. Pre-blast survey required. Approved charge weights applied. I thanked her and hung up. I hadn't decided anything yet. I want to be clear about that. I was still in the process of exhausting legitimate channels, but I am also a man who believes in knowing exactly what he has before he needs it. The variance hearing was 6 weeks out. I used every one of those weeks. The variance hearing was on a Wednesday evening in late January. Outside it was cold enough that your breath hung in the air when you walked from the parking lot. Inside the county building, the heat was turned up too high the way it always was in winter, and the room smelled like coffee and damp wool coats. Every seat was taken. People were standing along the back wall. I had never seen that room that full. Roy Steck was there. The 2 other adjacent landowners were there. Mrs. Pruitt was there in her wool coat with her canvas tote bag. Garrett was behind me. And there were others I hadn't organized, farmers and landowners from further out, who had heard about the hearing through the county grapevine and had come on their own. Some of them I knew by face. Some I didn't know at all. Marsh was at the front table with his attorney and his consultant. He scanned the room when he came in. I watched his face when he saw how many people were there. Just a flicker. Barely anything. But it was there. His attorney presented the variance application with the same polished efficiency as before. Hardship argument. The agricultural zoning classification made the property economically unviable for its intended purpose, given the investment Marsh had made in site development. Public benefit argument. A properly permitted venue would bring revenue and employment to the county. Compatibility argument. The surrounding land use was low-intensity agricultural and a well-managed venue would not materially impact neighboring properties. That last one was where they made their mistake. Marsh's consultant took the podium to support the compatibility argument. He said the proposed venue, when properly permitted and managed, would generate noise levels within county ordinance limits at all neighbouring property lines. He cited modelling software. He cited industry standards. He said with a straight face that the concerns raised at previous hearings had been based on conditions during an uncontrolled preliminary sound check, not representative of actual managed event operations. Uncontrolled preliminary sound check. That was what he called it. I wrote that phrase down in my notebook. When public comment opened, Garrett had arranged the order in advance. Roy Steck went first. He was a plain-spoken man and he spoke plainly. Drainage problems, access road incidents, dates and times. He put a typed summary on the commission table. The second adjacent landowner went next. Then the third. Each one had documentation. Each one had specific incidents, specific dates. The room was quiet while they spoke. Not the restless quiet of an audience waiting for something more interesting. The attentive quiet of people listening to things that mattered. Then Mrs. Pruitt stood up. She did not bring the tote bag to the front this time. She left it on her chair and walked to the podium with just a single sheet of paper. She put on her glasses. She read a prepared statement. It was 2 pages, double-spaced, and it took her about 4 minutes to read. She described living on her land for 44 years. She described the character of the surrounding area, what it had been, what it still was. She described specific dates and specific impacts. She read the decibel numbers from the noise consultant's report without editorial comment, just the numbers and the ordnance limit beside them. And at the end, she said one thing I had not heard her say before. She said she was 71 years old and had buried her husband on that property, and that she intended to stay on it for whatever years she had left, and that she was asking the board to consider whether granting this variance served the people who had built their lives in this county or the interests of someone who had arrived 8 months ago with a stage rig and a lawyer. The room was very quiet when she sat down. Then I stood up. I submitted 3 documents as formal exhibits: the Tennessee judgment record, the ticket stub from the December private event with a 1-page summary of the county code provisions on private event exemptions, and a letter from the state mining board confirming the current valid status of my blasting permit on the adjacent quarry property. I didn't say anything about blasting. I didn't need to. I just submitted the letter and let it sit there on the commission table with the other documents and sat back down. Marsh's attorney asked to see the mining board letter. The clerk passed him a copy. I watched him read it. I watched him lean over and say something quietly to Marsh. Marsh looked over at me for the first time in any of these hearings. I looked back at him without any particular expression. The board chair called a brief recess. The recess lasted 12 minutes. I know because I timed it. When the board reconvened, the chair announced that given the volume of public testimony and the complexity of the exhibits submitted, the board would be taking the variance application under advisement. A written decision would be issued within 30 days. Marsh's attorney requested an opportunity to respond to the mining board letter specifically. The chair said he could submit a written response within 10 days as part of the record. We filed out into the cold parking lot. Garrett fell into step beside me and said, "The letter did exactly what I hoped it would do." I asked him what that was. He said, "It reminded everyone in that room that you have options they hadn't considered." 3 days after the hearing, a man I didn't know knocked on my door. Late afternoon, a Wednesday. He was in his 40s. Dressed in the particular way of someone trying to look casual while representing something professional. He said he was reaching out on behalf of a party interested in exploring a mutually beneficial arrangement regarding my property. I asked him which party. He was not at liberty to say at this time. He said, "I told him I wasn't interested in arrangements with parties who weren't at liberty to identify themselves. I told him to have his client contact my attorney if there was something genuine to discuss." I gave him Garrett's card and closed the door. Garrett called me that evening. He had already received an inquiry, an email from Marsh's land use attorney expressing interest in exploring an easement arrangement for temporary access to the Quarry access road during event operations in exchange for compensation to be negotiated. Easement. Compensation. 8 months of unpermitted events, a cut fence, displaced cattle, 2 tabled permit hearings, 3 in the morning phone calls to the sheriff's office, and now he wanted to negotiate. I told Garrett to decline and to make clear that I was not interested in any arrangement that facilitated or legitimized event operations on the adjacent property. The Variance Board issued its written decision 26 days later. Denied. The decision cited 3 grounds. Insufficient demonstration of hardship. The applicant had purchased agriculturally zoned land knowing its classification. Adverse impact on adjacent landowners. The board cited the noise consultant report and the testimony of 4 adjacent property owners by name. And third, prior pattern of non-compliance. The board cited the open zoning violation and the 2 unpermitted events as evidence that the applicant had demonstrated a willingness to operate outside regulatory boundaries. That third ground was the one that mattered most. It wasn't just a zoning decision. It was a character finding, entered into the public record of the County Board of Zoning Appeals. Garrett scanned me the decision the morning it came in. I read it twice. Then I printed it and put it in the grey folder. The folder was nearly full now. What happened next I did not plan and did not anticipate. A reporter from the regional paper, a weekly that covered 3 counties, had apparently been following the permit hearings. Someone had told her about the variance denial, about the history of the proceedings, about the mining board letter. She called me on a Friday morning and asked if I would speak with her. I thought about it for a day. Then I called Garrett. He said it was my decision, but that if I spoke, I should stick to documented facts only, refer to the legal record, and say nothing speculative or personal about Marsh. I called the reporter back and agreed to a brief conversation. She was thorough. She had already pulled the public records, the permit applications, the hearing minutes, the zoning violation notice, the variance denial. She had the deputy's report from the fence cutting. She asked me questions, and I answered them carefully, with dates and document references where I had them. She asked about the blasting permit. I said it was a valid existing permit on my property, that I had held it continuously for 11 years, and that I had submitted documentation of its status to the Variance board as part of the public record. She asked if I intended to use it. I said I intended to exercise all legal rights associated with my property as I saw fit. She published the piece the following Thursday. The newspaper piece ran on page 3. By Friday morning it had been shared several hundred times on the county Facebook group. By Saturday it had been picked up by a regional news aggregator that covered rural land use stories across the state. By the following Monday, Garrett had received calls from 2 other attorneys whose clients had dealt with Marsh Event Group in other counties. One of those calls was from Tennessee. I didn't seek any of that. I want to be clear about that. I gave one interview, stuck to documented facts, and went back to feeding my cattle. The spread of the story was its own thing, moving through its own channels, and I had no part in directing it. But it changed the pressure on Marsh in ways that the county proceedings alone had not. His social media, Marsh Event Group, had accounts on several platforms, began receiving comments about the story, questions about the Tennessee judgment, questions about the unpermitted events, questions about the fence cutting. His response was to post a statement saying the story contained inaccuracies and that he was committed to working constructively with the local community. He did not specify which inaccuracies. Garrett called me that week and said Marsh's attorney had been in contact again. More serious this time? Not an easement inquiry, an actual settlement conversation. Marsh was willing to discuss compensation for the fence damage and the livestock incident, withdrawal of the variance application, and a commitment to pursue only properly permitted events going forward. I asked Garrett what that was worth. Garrett said the fence and livestock damages were real but modest, a few $100s in materials, some documented weight loss in 2 animals, veterinary records I'd kept. The value wasn't in the damages. The value was in what we could attach to a settlement agreement in terms of binding commitments and penalty clauses. I told him to go back and ask for more. Specifically, I told him I wanted 4 things in any agreement: full compensation for documented damages, a formal written acknowledgement that the 2 unpermitted events had caused material harm to adjacent landowners, a deed restriction on the Callaway Tract requiring county permit compliance before any commercial event, with a civil penalty clause payable directly to adjacent landowners for violations, and a written retraction of the characterization of me as a holdout who would be managed. That last one, Garrett said, might be difficult to formalize. I said I understood that. I said include it anyway and see what he says. Marsh's attorney came back within a week. They accepted the first 3. On the 4th, they offered a letter of clarification rather than a formal retraction, language acknowledging that the characterization had been inaccurate and that I had at all times acted within my legal rights as a landowner. I accepted that. The settlement agreement was drafted over the following 2 weeks. Garrett reviewed every line. I read it twice myself, which took an evening. It was 18 pages. The deed restriction was real, recorded with the county, attached to the property title, binding on any future owner of the Callaway Tract. The penalty clause set $5,000 per event day payable, jointly to me and Mrs. Pruitt for any commercial event conducted without a valid county permit. $5,000. Not $1,500 like the county's civil penalty. $5,000 paid directly to the neighbours he had spent 8 months treating as obstacles. I signed it on a Tuesday afternoon in Garrett's office. Marsh signed it 2 days later. I was not present for that. I was home feeding cattle. The agreement also required Marsh to file a formal withdrawal of the outstanding conditional use permit application within 30 days. He filed it in 22. I don't know what his plans for the Callaway Tract are now. I haven't asked. The equipment shelter is still there. The stage rigging came down sometime in February. The graded field has been sitting quiet since the settlement. Quiet suits me fine. Spring came early that year. By March, the upper pasture was greening up and my cattle were spread across it the way they're supposed to be, evenly, unhurried, grazing in the quiet. No bunching at the far end. No displacement. Just animals doing what animals do when nothing is disturbing them. I repaired the south fence line properly in late February. New posts, not just the 2 that had been affected by the cut wire. I did the whole run while I was at it. Takes a day and a half when you do it right. I worked alone, the way I prefer, and when I finished I walked the line from corner to corner and it was solid. Mrs. Pruitt left tomatoes on my gate post that August. Same as always. Paper bag, same spot. I don't know if she knew how much that meant to me, but I think she probably did. She's that kind of woman. Roy Steck's drainage issue turned out to be unrelated to Marsh's grading, a blocked culvert on the county road. The county fixed it in April after Roy filed a separate complaint. He told me about it at the feed store one morning and said the experience of the variance hearing had taught him that filing complaints actually worked sometimes if you were persistent enough. I told him I thought that was about right. The grey folder is still in the filing cabinet. Top drawer. I haven't moved it back to the second drawer with the wire staples and the aerial photograph. I'm not sure why. Maybe because this isn't entirely finished. A deed restriction is only as good as the willingness to enforce it, and enforcement means staying ready. Maybe because I just got used to it being there within reach. The blasting permit renewal comes up in 8 months. I'll renew it. I always renew it. I've thought about what this whole thing was actually about. Not legally. Illegally it was straightforward enough. Unpermitted land use, noise ordinance violations, property damage, a zoning process that needed pressure to function. Those things have clear names and clear remedies if you're patient and organised. What I've thought about is the assumption underneath all of it. Marsh looked at my land and saw a resource. He looked at me and saw an obstacle. He assumed that the gap between those two things, between what he wanted and what I would accept, was closable. That given enough time, enough pressure, enough confident forward motion, I would step aside or be stepped around. He had probably been right about that with other people. People who didn't have the time or the resources or the inclination to fight it. People who got tired. People who didn't have a Garrett or a Mrs. Pruitt with a composition notebook or a filing cabinet with 11 years of quietly renewed permits in the top drawer. I don't say that with any particular pride. I got lucky in some ways. I had the right paperwork. I had the right lawyer. I had a neighbour who had been paying attention since before I thought to start. But I also did not move. That's the thing I keep coming back to. I did not move. Not when the survey crew showed up. Not when the grading started. Not when the events ran without permits. Not when the fence got cut. Not when the county moved slowly. Not when Marsh's consultant stood at a podium and called my documented noise readings an uncontrolled preliminary sound check. I did not shout. I did not threaten. I did not do anything that couldn't be written down in a notebook with a date beside it. I just did not move. And eventually, because I did not move, everything else moved around me. The county found its enforcement mechanism. The variance board found its backbone. The newspaper found its story. Marsh found his settlement calculator and did the math and decided that managing me was going to cost more than it was worth. The land is still mine. The permit is still valid. The cattle are still grazing. Some mornings I stand at the western fence with coffee and look across at the Callaway tract, and it's just a field, flat, quiet, pale in the early light. Whatever Marsh does with it next is his business, so long as he follows the rules that apply to it. And if he doesn't, well, the filing cabinet is right where I left it.